Hi, thank you for being with me another time. This is Legal English. Today we're going to talk about court rules. My name is Felipe Velez, and I'll be more than happy to help you to understand what is the court procedure, what are the rules in a court of law. So whenever we talk about a court of law, we have to understand what are the basis of this terminology, if there is any legalese, or if this legalese has to be understood by other means. So, court rules. Repeat after me. Court rules.
Court rules.
Very good. Again, court rules.
Court rules.
Code rules.
Very good. So let's see what are the court rules. Well, first we have rules for family law. So we will understand this as family law. Pronunciation, family law.
Family law.
Very good. Then we have general civil cases.
General civil cases.
Small claims.
Small claims.
Very good. So family law is going to be for any matter regarding family. General civil cases can be contracts, it can be bonds, or anything that may come with it. And then small claims is going to be about the quantity, how we can start a prosecution, but it's going to be on a criminal matter. If it's not going to be a prosecution, then we're going to start with easy things. I mean, small claims is going to be for personal things, things that you broke. Probably you were in a party and you broke a TV, or you broke a TV headset or anything, so you can pay for it. So as you're going to pay for it, it has to be under $5,000. If it's under $5,000, then it can be on the small claims court. So let's continue. So we have family law, and this includes divorce, child custody, child support, and adoption cases. Again, pronunciation, divorce.
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 Again, very good. Child custody.
Child custody.
Child support.
Child support.
Very good. Adoption cases.
Repetir.
Adoption cases.
Under shock cases.
We say repeat. Can you say that again or repeat again? Adoption cases.
Under shock cases.
Very good. General civil cases.
General civil cases.
Very good. This involves disputes between parties over rights and obligations. Common examples include contract disputes, personal injury cases, and property disputes. Again, pronunciation, contract disputes.
Contract disputes.
Again, contract disputes.
Contract disputes.
Very good. Personal injury.
Personal injury.
Personal injury cases.
Personal injury cases.
Property disputes.
Property disputes.
Very good. Small claims.
Small claims.
Very good. Small claims court.
Small claims court.
Is for cases where a little bit of money is involved, which is $5,000. This is the general limit for most claims filed in a small claims court. Okay, so let's go into Spanish and find out. Family law, we're going to say derecho de familia o derecho familiar. General civil cases is going to be casos en general de litigio civil. Small claims is going to be juicios civiles de cuantía menor, small claims court. So let's understand. Family law understands and includes divorce, divorcio, child custody, custodia de menor, y pensión alimenticia, we say child support. Pensión alimenticia, child support. Adoption cases, casos de adopción. Everything is on behalf of family law. General civil cases, casos en general de lo civil. This involve disputes between parties over rights and obligations. Usualmente van a ser sobre disputas entre derechos y obligaciones. Common examples include contract disputes, es disputas contractuales, personal injury cases, it means casos de daños a terceros, and property disputes, y disputas por propiedades. Small claims court is for cases where a little bit of money is involved, $5,000. This is the general limit for most claims filed in a small claims court. Entonces, en las cortes de cuantía menor, de lo civil, la cuantía por particulares tiene que ser de $5,000, $5,000. So, let's continue with this. Probate law, pronunciation, probate law.
Probate law.
Law.
Very good. Probate is a legal process that deals with the assets of debts and of a deceased person, known as the descendant. So the descendant has to be the person that's going to be dead. So this person that died, he is going to inherit values, assets to other people. So for that, in order to understand who are going to have all of this, we're going to use probate law. And then we have a declaratory relief, which comes with the probate law. In a declaratory relief, it is commonly used in situations where there might be a disagreement about the interpretation of a contract, the rights of under will, or trust. So let's see. How is this going to be? Probate law, it talks about a person that has vanished. So this person that has vanished, is dead, is deceased, we're going to use probate law. And then in order to have an agreement upon all the assets that this person has, we're going to use a declaratory relief. Okay, so let's practice again. Probate law, pronunciation, probate law.
Probate law.
Probate law.
Es derecho sucesorio. Probate is a legal process that deals with assets. Juega o tiene que ver con los activos, los bienes, activos o bienes, we use the word assets. And debts, bienes y deudas. Of a deceased person, de una persona fallecida, known as the descendant. So this descendant es de cuyos, le vamos a decir descendant. Para que haya un entendimiento entre partes, vamos a usar una declaración de alivio. A esto le vamos a llamar declaratory relief. Pronunciation, declaratory relief.
Declaratory relief.
Entonces, ¿qué es un declaratory relief? It's commonly used in situations where there might be a disagreement, cuando hay un desacuerdo entre la interpretación de un contrato, contract, or the rights under a will or trust, o los derechos que hay en un testamento decimos will or trust. Trust, la palabra trust se puede entender como legado. Entonces, el legado, trust, o también lo podemos ver como en algunas situaciones como fideicomiso. Depende mucho el contexto. Okay, so again, pronunciation, probate law.
Probate law.
Probate law.
Declaratory relief.
Declaratory relief.
Again, probate law.
Probate law.
Declaratory relief.
Declaratory relief.
Again, declaratory relief.
Declaratory relief.
Very good. So let's continue with this. So, how do we go from the civil procedure? Can we do it online? Yes, you can. And we're going to teach you how to do it by yourself online. Also, one of our attorneys can help you out to do it. But if you can handle it, don't worry. You will be able to do it by yourself. Let's see if you can handle it. So in order to use the civil procedure, we have to understand how to file a lawsuit. So we're going to start small. We're going to start with a small claims lawsuit. So what is the law background? Under CCP section 116.320, a plaintiff can commence an action in small claims court by filing a claim under oath, always under a promise to say the truth, with the clerk of the court. The claim form is a simple, non-technical form that requires basic information about the defendant, the amount and basis of the claim, and an acknowledgement that the judgment will be conclusive without a right of appeal. So, again, pronunciation, a plaintiff can commence action. Okay. So, el jus petitio, we're going to say to commence action. La parte quejosa o actora, we say plaintiff. Again, pronunciation, plaintiff. Plaintiff. Very good. So when we say he can commence an action, it's a legal word to say that él puede iniciar una acción legal. So commence action. Pronunciation, commence action.
Commence
action.
Very good. In a small claims court. Entonces, ¿cómo se dice corte de cuantía menor en materia civil? Small claims court. By filing a claim under oath, puede promover una demanda. Promover decimos filing. filing a claim. Claim es demanda. Pronunciation claim.
Claim.
Under oath, bajo promesa de decir verdad. Under oath, again pronunciation, under oath.
Under oath.
Under oath,
Under oath.
very good. Es bajo promesa de decir verdad. Entonces, toda la palabra de promesa de decir verdad le decimos oath, que es juramento. With the clerk of the court, con el auxiliar de sala o con el secretario de acuerdos, is the same. Clerk es asistente, court sería el asistente de la corte. En a law firm, en un despacho, tenemos abogados que son clerks. Clerk significa que son asistentes. Entonces, igual en la corte decimos clerk, court, so it's a clerk of the court. The claim form is a simple non-technical form that requires basic information about the defendant. Entonces, para poder promover una acción civil, una demanda civil, tenemos que hacer o llenar un formato simple, no técnico, que requiere información básica del acusado. Entonces, ese acusado se llama defendant, pronunciation defendant.
Defendant.
Very good. Entonces, el acusado o, en este caso, el demandado, porque es materia civil, le decimos defendant. Again, pronunciation, defendant.
Defendant.
Very good. The amount on the basis of the claim. So what are the most important things about the claim? The amount of the basis of the claim and who's the defendant. ¿Cuál es la parte más importante de la demanda? Describir al demandado, es decir, quién es, dónde vive, a qué se dedica, y la base del reclamo. The basis of the claim. Pronunciation. Basis of the claim.
Basis of
the claim.
Very good. So, and an acknowledgement that the judgment will be conclusive without a right of appeal. Con el reconocimiento que en el juicio va a ser conclusivo sin el derecho a una apelación. Entonces, lo difícil de una small claims court es que una vez que hay una sentencia, no se puede combatir. ¿Por qué? Porque es una sentencia que no equivale a más de $5,000. Let's continue. So what is the first step? To select your venue. So to understand the venue, it's where you're going to take this court. So if the amount of money that is owed is under $5,000, then yes, you can take it to a small claims court. If it's not under $5,000 and it's greater than $5,000, then you have to go into a superior court. But if you're a company, then you can still file under $10,000 in a small claims court. Anything else or greater than $10,000, it has to go to a superior court or a higher court. Entonces, lo más importante al momento de promover tu demanda en lo civil en los Estados Unidos es ver qué tipo de dinero se te debe. Si es un dinero de cuantía menor, es decir, $5,000, es decir, menor a $5,000. Si es menor a $5,000, sí puedes promover en una small claims court. Si es un particular el que lo debe, es decir, una persona física. Si no es una persona física y es una empresa la que está reclamando ese dinero, menos de $10,000, entonces la empresa puede ingresar la demanda en un small claims court. Si no puede comprobar la cuantía, entonces se va a una corte superior si supera los $10,000, incluso con los intereses. So, we have to understand, if you don't do the proper venue, you're going to lose your money because all the percentages are going to be calculated or miscalculated under the wrong venue. So once you understand that, we have to go and start doing it. In order to file a claim, you have to understand the three parts that are going to help you to file a lawsuit. First, the court clerk, then your attorney, and then your judge. So the court clerk is going to help you to understand your claim and see if there is a remedy, if there can be an agreement. Your attorney is the one that's going to tell you how to represent yourself. He can teach you how to do it by yourself, but here in California, he cannot represent you. You have to do it by yourself. And a judge will be able to take your claim and see if it's understandable or if it needs more proof or if it needs more understanding of why you're claiming this money. So, again, para promover una demanda, necesitamos ver el fundamento legal que está en el Código de Procedimientos Civiles de California en su sección 116, 3.20. Y lo que nos dice es quiénes son las partes que te van a ayudar en la corte. Entonces, entre estas partes está el auxiliar de sala o el secretario de acuerdos que se llama court clerk, pronunciation court clerk.
Corporate.
El abogado, again pronunciation attorney.
Attorney.
Attorney es un abogado que practica derecho, pero en una corte de small claims no te puede representar. Está prohibido que un abogado te represente en una corte de cuantía menor. ¿Por qué? Porque es una cuantía donde solamente acuden las personas que quieren resolver los problemas por su propia cuenta. Entonces, un abogado puede entorpecer estos trabajos. Y además, a la mayoría de los abogados no les conviene ir por $1,000 o $2,000. Entonces, ese dinero es para ti. Pero él sí puede ayudarte a entender cómo proceder con esta demanda e incluso te puede ayudar a rellenarlo. Y también puede probarte los $1,000 o $2,000 que él pida. Si estás dispuesto a perder esos $1,000, $2,000, adelante. The judge, el juez, va a resolver sobre tu claim. Si tu claim is all right, I mean, if it's liable and if there are enough grounds to perform this venue, then you can provide enough remedy for the counterpart, then yes, you can start with your claim. If not, he's going to dismiss your case. Okay, so let's start with the next. So in a small claims court, how do we determine the eligibility? If it's between $5,000 and $10,000. $10,000 are only for companies, and only for people it's going to be $5,000. Then remember, you have to gather information regarding information about the defendant, where the defendant works, if he has enough money, or if you have enough evidence. So if you have enough evidence, then enough right background, so then you can perform intelligence, and in this intelligence and documents, then you can have a fine lawsuit. Then you need to fill out the court forms, which is form SC100. We're going to check it there. And then you need to find where is the court location, check the filing fees, and get multiple copies. When you understand that, then you're all set. You're all set to perform what? To perform what we call to serve. It means who you're going to serve is going to, you have to find a service of process. The service of process is going to be a company or somebody that can serve a copy of your claim to your defendant. So remember that serving the defendant is very difficult because you have to locate the defendant and serve the defendant. So once you locate and serve the defendant, he has to answer if that legal claim is valid or if it's not valid. So in that way, you have a service of process, and you have to be legally notify or serve the defendant with a copy and provide proof of service. So you need to find the defendant, serve him a copy. Remember, you can't serve the defendant yourself. It has to be a service of process. Okay, so let's review all of this. Entonces, asegúrate que cuando vas a file, vas a promover una demanda en cuantía civil, de cuantía menor, tienes que ver que sea entre $5,000 y $10,000. Tienes que juntar información del defendant, es decir, del acusado, de quien tú le vas a demandar, juntando toda la inteligencia que tengas de la persona, dónde vive, a qué horas va a trabajar, si tiene un trabajo, cuáles son los horarios para irlo a notificar. Los documentos que van a ser la base de tu demanda. Una vez que tengas esta información, entonces ya puedes llenar el formato S100, el cual vamos a ver en un momento. Entonces, en ese formato S100 vamos a rellenar, literal, cuáles son los datos que nos va a pedir la corte. Entonces, ¿cuáles son los 3 elementos principales que necesitamos antes de promover la demanda? Es dónde está tu corte, si esa corte tiene jurisdicción sobre el defendant. Si está en un county, es decir, en un condado, donde tengas que promoverlo ante una corte de ese condado. Y el filing fee, cuánto cuesta literal demandar a la persona. Y las copias que necesitas para promover la demanda. Es decir, necesitas darle una copia a el acusado. esas copias, una copia para el que va a notificar y otra copia para la corte. Entonces, una vez que tienes todo eso, puedes seguir con el siguiente paso. ¿Cuál es el siguiente paso? Encontrar al acusado. Nosotros, a través de la inteligencia artificial, con lo que llamamos Cyber Intelligence, podemos encontrar al acusado. Si no puedes o no puedes pagar el servicio, tú lo puedes hacer tú mismo. ¿Cómo? Buscando al acusado. ¿Para qué? Para que sea notificado. Entonces, ¿quién puede notificar a un acusado? Tiene que hacerlo una persona autorizada. A ese le llamamos Service of Process. Alguien que puede servir, literal, al acusado. Así le decimos serve the defendant. Entonces, no tenemos actuarios, ni tampoco personal del juzgado va a ir a tocarle la puerta al defendant. Va a ser una compañía o va a ser una persona habilitada como Service of Process. Entonces, este Service of Process le tenemos que pagar para que vaya en un horario que tú hayas encontrado, que es donde se puede encontrar a la persona, y literal, localizarlo y notificarlo. Locate and serve. Una vez que lo localicen y lo sirvan, literal, lo notifiquen, entonces él tendrá ya la demanda en sus manos y empezará a correr el término perentorio. Entonces, primero tenemos que ver dónde está el acusado, darle su copia y recuerda, no lo puedes servir tú, es decir, no lo puedes notificar tú mismo. Necesitas ser o tu abogado, en dado caso que decidas que sea el abogado. Puedes hacerlo, puede ser un service of process o puede ser un policía, pero también se le tiene que pagar a los policías. Okay, so all of this is if you can start a small claims court. Do you have any question regarding this? Do you have any question?
No.
No,
Okay, very good. So,
el
yes.
service de defendant son personas que